Hey folks, I'm attorney Roger P. Foley, and today we're going to talk about the criminal justice system in South Florida specifically, and what I refer to as the ugly truth. Here it is. I've worked in several counties. I've had cases in Dade, I've had cases in Broward, I've had cases in Palm Beach, I've had cases in Martin, I've had cases in St. Lucie, and I've even had some other cases in various counties. Here's what the system has become, and this is just during my term as a defense attorney. When I first started out, there was a process. I was taught a process, and the way the process began was someone gets arrested, they go to magistrate court, right? Magistrate court is the first appearance. So what happens at the first appearance? First appearance, not much happens. You rarely even need an attorney. It's helpful if you have one, but generally you don't even need one. What happens? The judge reads a police report, right? Says, all right, I see that according to what the police officer wrote, it fits the elements of the crime, and I find that there's probable cause that you, sir, or you, ma'am, committed whatever crime, a DUI, economic crimes case, whatever it may be. And I set your bond at this amount, right? That's how it started. Now it's changed a little bit. You know what happens now? Now they do the same process, except instead of setting a bond, a monetary amount where you pay 10% to a bondsman to get out, now they usually place you on pretrial. It's becoming the norm. Pretrial was set up for the homeless guy who got a trespassing charge, who had a bond that was $25, but would get stuck in jail for 3 months because he couldn't come up with 25 bucks. That's what the process of pretrial was supposed to be for. But what is it? Just in, I don't know, the last 6 years, last 8 years, it has become where almost everybody is on either pretrial or SOR. Just for folks out there, pretrial and SOR is just another way of saying that the government is going to supervise you. You're going to pay them a fee as opposed to the private company out there, the bondsman, and we're going to monitor you monthly, weekly, daily, hourly, by the minute, right? That's the reality. You have to go check in with pretrial on Tuesday at 3 o'clock, and when you have court, you got to come right after court, and if you don't show up, or if you're late, or if you piss off your pretrial release officer, you can go back into custody for violating the conditions of your pretrial. What are conditions of pretrial? Oh, you don't get to go anywhere. You can't go anywhere. You're not allowed to leave the city or the county without permission. You can't drive up to Orlando to go to Disney with your family. If it's a Christmas holiday or some other holiday, or it's your birthday and you're traveling, you got to get special permission from the court to be able to travel. It's a big mission. It's basically you have the government as a babysitter and you can't do anything. Well, I thought you were innocent. What happened to innocent until proven guilty? Sir, you leave that county, I'll have a warrant for your ass. That's the reality, folks. You're not innocent until guilty. You're really guilty until innocent. And I'm a defense attorney telling it to you. I'm telling you the ugly truth. So what's step two? Step two is your case paperwork goes over to either a case intake attorney or a case felony attorney. And what are they? They're just someone who reads the report, and they're supposed to sniff through the BS. They're supposed to go, oh, okay, the cop didn't do it this way, or he should have did this. They can either keep the charges exactly the same, put a rubber stamp on it. They can increase the charges like, hey, actually, the police officer wrote all the facts. He just had the wrong charge. It should be this charge, not this charge, and increase. Or he can decrease them, right? And normally when I started, it was, hey, Mr. Case Intake, hey, Miss Case Intake, I'd like to humanize my client. I want to tell you a little bit about my client. He or she has no criminal history. These are the facts that I'm proffering to you. I know that they're not under oath, but I'm proffering to you. Hey, I have some witnesses. Could you, before you make a case filing decision, would you take a look at them? And you know what? 8-10 years ago, seriously, I think it was like 90% of the time, I'd get a call back. They would take a look at my evidence. We would delay in their case filing so they could do a little bit of investigation, make a decision. 2016, hey, Mr. Case filing attorney, I have 2 witnesses that witnessed, the officers, abusing my client. Yeah, that's nice. We have 15 officers that say he doesn't, Mr. Foley. Yeah, but I have 2 independent witnesses over here that say that that's not how it went down. And I mean, they don't even know the clients. Yeah, that's nice. We got enough to file. Good luck. They don't care. So what's happening? First, right? The magistrate judge only hears the police report, right? The second person in charge, right? The next person who's going to deal with the case intake or the case filer, they're looking at just the police report. Boom, rubber stamp it or increase the charges half the time, right? Now, so what is the defendant thinking? A defendant's like, man, the judge didn't listen to me. I didn't get to tell my story the first time. The second part, my attorney said that the case intake or case filing attorney is gonna listen. He'll be able to talk to him. If they call you back, it's a miracle half the time. Then what happens? Well, now the case gets assigned to a prosecutor who's going to be, bringing the case forward. He's going to prosecute the case. So what happens? The prosecutor gives you your discovery, all the information that they have against you. You have to be very detailed because now it's becoming, hey, you have to go get your own stuff at the police department. You have to go to evidence. And it's eating up defense attorneys' time. You're supposed to get the evidence. Well, sure, we have it, but you need to go call the police department to get that. Or, hey, I don't know anything about that. And then I don't know. And hey, if I don't know about it, how am I supposed to give it to you? Even though the case law specifically says, right, that all Brady information, all information against the client, if the officer knows, the prosecutors are assumed to know no matter what, because they're another arm, right? They're another agency of the government. They're all supposed to know the same thing, that they're supposed to have that information. But it's becoming longer. It's like little battles within battles to get information, right? So what is the criminal defendant doing? He's sitting there going, hey, what's going on? And the attorney is saying, like me, hey, I filed my motion. I let the court know. I let the prosecutor know. I requested my discovery. Hey, I'm waiting, a month, 2 months, 3 months. You're supposed to get your discovery within 30 days. Does that happen ever? It's pretty rare. Usually somewhere between 30 and 90 days. I've had cases where I didn't get discovery for 5-6 months, but those are real big cases. As long as my client's out of custody, who cares, right? But what's the ugly truth is that the humanizing at the case intake, the case filing where they listen to your story and that's not happening anymore. Defendants aren't getting the benefit of the doubt. They're just assumed whatever the officer wrote is the truth. So you have these officers who are writing extra things, right, to get their guy, or you piss them off, they didn't like your attitude, whatever it may be, and the cases are being filed. Now what happens? So you're waiting for your discovery, and you go to court, and what does the judge do? Hey, you guys need to come up. What's going on with the case? Where are you going? What are you doing? Well, everybody wants a neutral judge, right? I mean, when you hear about a judge, like our mindset is he's a neutral guy. He's a smart guy. He's the smartest guy or he's the smartest woman in the courtroom, and he listens to their side, and then he gets to listen to my side, and then he kind of deciphers like the BS, right? Hey, that's not. I mean, I was by myself, I'm 120 pounds, and I came at, 6 officers that had guns at me in an aggressive stance and ran towards them, and I've never had a drug in my life. And after they shot me, they drug tested me, and I had no intoxicants in my body because I was tested at the hospital. Right? Wouldn't you kind of read through some BS for that, right? If an officer wrote, he came at us and then we had to shoot him, right? Something like, they're not. So what are the judges doing? The judges really these days, folks, they're either police officers with robes over, and I'm not saying every single one because there's some good judges out there, but generally, like if I was to just generally throw out, a stereotype of a judge, he's a prosecutor. He's a prosecutor who used to be a prosecutor who now has a bigger pension, as a judge. And he put a robe over his prosecutor uniform, or he or she put a robe over his or her police uniform. That's the ugly truth. This is the ugly truth about what's happening, right? So now we go to court, right? And the prosecutor says, okay, well, I'm going to offer you this deal. That's all it's become, folks, is we're dealing and negotiating like we're buying a bicycle. Listen, your client has, 28 grams of weed. I'm going to offer him 2 years of probation, 6 months of community control. He's going to take a drug class. He's going to be drug and alcohol tested. And they're haggling. So, you know what? The crappy lawyers that aren't really good at doing anything and arguing in a courtroom and persuading and deciphering evidence and investigating a case, killing it because 96% of cases, 96% are being pled no contest or guilty. Like, maybe 92, 96, 98. Geez, it's in the 90 percentile. They're being played guilty. So when you hire an attorney, what are you getting? Who knows? Hopefully you have an attorney that will fight. But what does really fighting mean? Well, I go to the prosecutor and I go, hey, Charlie, hey, Susan, let me proffer some evidence from my client. Listen, I have a video that a third person videotaped the police beating or whatever it was. There's a video of something going on and it will help shed light on the facts of the case. I'm telling you, in 2016, I'm at the point where I'm showing people videos. I'm sending information, evidence to the state attorney. I'm giving state attorneys witness lists, and they don't care. Okay, well, have your fight in court. And why is that particularly bad in Broward? You know what? I'm going to pick on Broward today. Broward County Courthouse, right? Let's say I have a third-degree felony. Let's call it, I don't know, a bat Leo. Let's call it a grand theft. And I have some evidence. Let's call it a bat Leo because there just seems like so many bat Leo, battery on the law enforcement. There's so many cases these days. Hey, state attorney, I got a witness. I got an independent witness that doesn't know the cop and doesn't know the thing. Yeah, we don't care. We're going to go forward. That's what case intake will tell me. Case filing will say, you know what, I got 5 officers that said that your client did it, so we don't care. That's not the way it's supposed to be, and that's the supervisor will say, well, that's not right. I mean, I don't know why they're doing that, Mr. Foley. I'll have a conversation with them. It's all bullshit. No one's doing anything. They don't care about the humanizing effect. They don't care about independent witnesses. Unless you have a video camera and you're on channel 5, channel 7, CBS, NBC, unless you're putting that in their face, guess what? Cases aren't getting dropped. So what you're ultimately doing is you're hiring an attorney to go, hey, Susie, this is the facts that I got. They try to humanize. They give their best effort. And the prosecutor goes, listen, I'm a third-degree felony prosecutor. I have no power. Look, I agree with you. This is stupid. But guess what? I went to my supervisor. And this has happened, folks. So I'm not bullshitting. I just can't talk about any particular case. I've talked to the supervisor, and I told him, I don't think this should go forward. I think we should dismiss it. We should decline to go forward. And they told me, you're being paid to prosecute. Prosecute the case. There's enough there for you to be victorious. Since when is enough there? It's like people are prosecuting to prosecute. Like, I don't know the budget. I don't know how much money is coming in court costs that's going to the state attorney's office. I don't know how much state funding and grants are coming in from the federal government to the state. I don't know. I don't know how that part works. But people are being prosecuted just to prosecute. Like, hey, just prosecute. No, but there's evidence that's contrary, right, to the facts set forth in the information or the police reports. There's witnesses there. There's information that goes, hey, you know what? That doesn't sound right. But they're still going forward. That's the ugly truth. You move up the chain. Well, because third-degree felony prosecutors in Broward County, they can't do anything, right? They could agree with me all day long, but guess what? They can't do anything. So what do? Well, listen, I can talk to a supervisor. Well, how much salesmanship, right? Remember, we have a state attorney, respectfully, and there's a lot of nice state attorneys, a lot of great people out there, but are they going to sell like from the heart? Are they going to put the passion into it and they go, hey, boss, listen, there's this guy who I really, really think is innocent. He's innocent. Like, I mean, my gut tells me, I listened to the defense attorney, I got the evidence. He showed me some things. We talked about it, proffered some information to me, and he's just, there's no way we should go forward. No. Hey, boss, listen, I spoke to the defense attorney. He asked me to talk to you about possibly changing the charge from a bat Leo to a resisting without violence. Okay, the supervisor, why would you do that, Bill or Harry or Susan? Right. Well, there's not a video, there's not any evidence. The defendant has a bunch of bruises on it. The officer doesn't really have anything on. Listen, you're paid to prosecute, go prosecute. They're not dropping charges down. They're just not. Now, does it happen? Yes. I've had a gazillion cases that have been dropped down, but generally speaking, they're not doing anything. They're basically saying, have your day in court. And I understand that premise, right? Because that's what our court system is premised on, right? Have your day in court. But what does have your day in court in Broward, Palm Beach, right? In South Florida, what does it mean? It means that you risk everything. You're all in if you're gambling, right? You are all in. If you go to trial on a felony charge and you lose, You are going to prison. Period. Period. You're going to prison. That's the ugly truth, right? So what are your options? You're paying an attorney to fight a case. Let's say it's, you're paying someone like me to fight a second-degree felony. You're probably spending, 10, 15 grand. You're spending a lot of money. You're hoping that your attorney's going to take depositions, get some investigative information, and start to punch holes, right? But what we normally do, what I was doing 10 years ago, was I was taking those weaknesses in the case and I would show it to the prosecutor, right? And the prosecutor would be like, yeah, I understand what you're saying. We could lose. This is what we're doing. But there's been a whole shift. Now it's like, yeah, that's just not very, not very persuasive. So, here's your offer. You can do prison, you can do jail, you can do probation, whatever our offer is to you. Or you can go to trial. So what does a client do? Like a client seeing the first judge doesn't care. Client sees that the prosecutor doesn't care. The client sees that the judge is trying to hurry the case up. Like, hey, I don't really care what you guys do. Sir, you'll have your day in court, but just know that if you go to court and you lose, that, you very likely could go to prison. Now, he's not warning him that he's going to send him to prison, but he has to let him know that he's facing the maximum of 5 years or 15 years or 30 years or life or, whatever it is. So the judge tells him that. And what are defendants doing? They're shaking because even though they know that they're innocent, they're scared of the system. They don't trust the cops. They don't trust the prosecutors. They don't trust the judges. And a lot of times they don't even trust the defense attorneys because they're going, hey, man, you're being paid to persuade these people. And then defense attorneys are going, look, I can only tell them the story. If they don't care, they don't care. They've offered you this. So you have option A, plead guilty or no contest. Or option B is go to trial. Now, obviously, on a lot of cases, there's motions to suppress, and that's sort of my forte. And what I like to do is I like to find technical arguments that have a case dismissed on a technical argument. The police didn't do something, or they violated your rights, a Fourth Amendment, a 14th Amendment. But because judges are generally policemen with uniforms on and prosecutors with uniforms on, they're not really neutral. So if I tell one story with my client's friend Bill and one story comes from the police officer, the judge goes, well, I listened to both and I just find the officer more credible. Why? You don't know him. He didn't say anything that was more credible, but because he's got a uniform, a badge, and a gun, and he swore to tell the truth. But my guy might be a business owner. He may be a guy that works construction, another regular guy in the community, but apparently his opinion, his testimony isn't as credible as a police officer. Even though judges specifically say every day during trials, you can't believe a police officer over a civilian witness. You need to listen to both of them, weigh the evidence carefully, pay attention to their testimony, and make a decision on who you think is more credible. 99% of the time, 99.999, the ugly truth, folks, is the judge is going to say that the officer is more credible. So your success ratio on your motions to suppress are going down, even when you have case law. And then what happens at the appellate court? The appellate court assumes that the trial court did the right thing. That's the rule of law. We assume that they read the facts, they understand the facts, and unless it's just something that's way out of control, they go, I can understand, possibly it could be more credible. That's the ugly truth. The ugly truth is that police officers are overcharging people. Police officers are hitting people, hurting people, harming people, mentally, psychologically, physically, and the system is failing us. The system is failing us. That's the ugly truth. So what do you have at the end of the day? You're charged with a crime, whatever it is, misdemeanor, felony, whatever it may be. Here's the truth. Your attorney says, prosecutor, judge, here, let me get all the information. They get it. They try to humanize you. They don't really care. And then they make an offer. We'll give you 3 years of probation. We'll give you a year of jail, followed by 3 years of probation. Or you can go to trial. But that's your option. That's what the system has become. 90-something% is plead guilty or no contest and get a punishment and have a record. And then the other people are just having to, you're either crazy and you're cuckoo and you'll just go to trial for anything, or you're a principled individual who's going to risk their life, their freedom, to have your day in court and pray that the attorney, someone like me, can convince someone like the rest of society, your next door neighbor, that you're innocent of the crime. And if I can't, you're going to prison. That's the ugly truth. So when you hire an attorney, you know you got three options, right? You got your plea offer, whatever it may be. You have possibly a motion to suppress. That's only sometimes. And then you have an option of trial. So in all cases, you have an option of taking a plea bargain or a trial. And in some cases, there may be technical arguments that you can argue. That's the ugly truth. The system doesn't care about you. They don't care that you have a kid. They don't care that you have family. They don't care that your elderly parents are sick. They don't care that you're the breadwinner in the house. They don't care. They don't care. They don't care if you save 6 babies, from a burning building. They don't care if you gave mouth-to-mouth resuscitation on an infant, 2 weeks ago when you were in the news. They don't care. And if your case gets in the news, they even prosecute you harder. That's the reality. That's the ugly truth of the criminal justice system. I'm attorney Roger P. Foley. I'm giving it to you straight.